Okay, we are live now.
Okay.
Okay, hi everybody. Happy Friday. So today is very different that we have a accident that my assistant is not feeling well, so she made me realize I need her very much. So I'm using my iPhone at the last result. So maybe the sound not as good. So today our guest speaker, our expert speaker is Jeremy Wang, the famous attorney. And
not that famous.
No, he's famous. So the last two episodes that we talked about, we had Tony Yeung from Invest Bank talk about lending, and then we have Katie Hu, the tax director, talking about the tax planning before you purchase. Then as broker, then we take the buyer out to shop, and the next thing would be you will need an attorney. So just let you know that this episode will focus on many fundamentally basic information that buyer need to know, and based on Street Easy, the statistic. In 2016, in Manhattan, we have about 77% of residents are renters. And among the New York City, people spend about 62% of their gross income on the rent, and in Manhattan about 49%. Further statistic, Street Easy has very very interesting calculation called tipping point. Basically, what it means that tell you your home ownership in certain area, how based on the local rent, how long would it take for you to recoup. So it suggests that if you plan to live in Manhattan for over 5 years, then it is better to buy, purchase versus rent. So here you go, that we are going to go enter the legal aspect. When you like an apartment, because we know that there are 77% of us are renters, and so we will take you through the very basic legal aspect in the transaction. And when let's say you find a property, and then I represent you, the following process that we will submit the following information to the seller and the seller broker: your full legal name, how much down payment, the amount of financing, whether it's a finance contingency or non-contingency. Jeremy will explain that. And your financial statement, a statement that shows how much assets and how much liability, and your annual income, and your monthly housing cost. And then with your mortgage pre-approval letter, and then your attorney contact information. In Manhattan, in New York City, the real estate transaction, we do request that you have buyer to be represented by the attorney. I know it's different from other area, but this is a very critical part. So the following 3 items we will send to the attorney from the seller side: offering plan, building financials, usually the last 2 years of building financials, and house rules about the building. And so I'm going to give this to Jeremy, and so Jeremy's our rising star.
I'm happy to be here today, but so we're going to be answering some questions today about the condop or co-op process. So
yeah, so I know the question will be very basic. However, a lot of people actually don't quite know throughout the whole transaction. They simply sign this contract without fully understand what exactly the attorney does for them. That's what this episode is about. So let's start from the basic, that in Manhattan, we know we have a townhouse where you are the king of the whole building. In the apartment building, that if you purchase an apartment building, you have co-op and you have a condo.
Whereas in condo, you're getting a deed for ownership. That's the most common sense. So what's the difference between real property and personal property? Well, real property is real estate, it's dirt. And that's what people understand when they're buying property. It's like, oh, I'm gonna buy some real estate. Co-op technically is personal property. You're getting a stock certificate. So a building would be organized to be a privately held corporation. It would be issuing stock. So through that stock, you'd be a shareholder. And what does that mean? What kind of differences does that mean to be a shareholder compared to being a deed holder? Well, you'd have to be under the purview of the board. So like any corporation, there is a board of directors who delineates certain rules and aspects regarding to the building. You would have to adhere to those rules. Not to say that condos don't have those, but with a condo, since you have ownership, you physically own your actual unit. So you have more autonomy over what you want to do within the unit itself. Most people ask me, well, is it more difficult to purchase a co-op, more difficult to purchase a condo? I'd have to say it's more difficult to purchase a co-op. And the reason being that, one, you'll have to go through a board interview. More often than not, the board interview, you'll have to put it together a package. You'll have to submit it, and the board will meet and decide your fate, whether or not you're going to be approved. If you are approved, you move on to the next step and we could potentially close. Right. With the condo does not have the ability to do that. The condo only has the ability to issue what's called a first right of refusal. So the condo can purchase the unit from the seller at the same terms that the prospective buyer chooses to buy it, or they issue a waiver as such, and then the buyer can purchase.
Yeah, actually, that was actually one of the questions I was going to ask him later, the definition of the first right of refusal. And so Jeremy just mentioned it.
Right. The first right of refusal is the only power that the condos have. They can either exercise that right and purchase it as per the contract of what the deal between the seller and the buyer, or they issue a waiver. So
I'm going to start right here. I've been in real estate for 15 years. So far, among all the transactions, I personally have not experienced any case that where the condo they exercise their first right of refusal.
That is true. Okay.
Have you?
I've had one case.
Okay, can you sort of like under what scenario?
The reason why a lot of times the condos are not going to exercise their first right of refusal is because simply it's the money that comes from the condo, the reserves, and you don't have enough. All right. So if, in a sense, it'd have to be the perfect storm. The condo would have to have enough, and there'd have to be a reason to purchase it. Like the whole condo decided, hey, you know what? We need to purchase this unit for XYZ. We're going to do something with it. In this case, they exercised it because it was at a very low price.
Right.
They wanted, so that actually helps the condo in a sense, kind of preserve some values of certain units. So
stop right there. So in a scenario where, like, let's say a condo board member is interested in the unit that you're selling, can they use that as a reason to exercise the right?
Well, it's not for individual gain. So so that's the thing that you have to understand. It's not that somebody's going to come out and say, you know what, I want this condo. I'm a board member. This has to be under the purview of the board itself. So the money, everything is going to be a condo, the board's money. So it's going to be the building's finances that have to kind of say whether this can happen or not. It's technically not permissible to do that, although sometimes people believe that's what's going on. Going on.
So most of the time it really happens. But he just mentioned something. You do have experienced one case, right?
Correct.
Okay. So basically, it comes to, if you're investors, normally we only introduce condo to investors and not co-op, because it's co-op. Most of the time you will need to go through the co-op board approval process, and they have a right to reject you without disclosing the reason. But what about a condo?
A condo, I don't want to get too complex, because the truth is a lot of condos, the way they're organized, it's because they fall under a category. They have a portion of the building which is a commercial, and that's organized under some sort of a commercial condo, and then they can kind of have this special classification. For most regular lay people, their point of view, what is it? It's just a co-op operating under condo rules. So when you see a condo on the market and you say, well, I wonder what this is, understand that you'll still be getting a stock certificate. You're not going to get a deed at closing, but you likely will be operating under condo rules. Likely no interview, and there's more autonomy of what you can do the apartment. Perhaps rent it out. No, you don't have to go through the board of doing that subletting or various things for construction.
So just for the buyer to know that we normally know that on the market, given the same type of property, if one this is given the same location, if one is co-op, one is condo, normally we will see the condo price will be higher due to its popularity and ability, flexibility for you to use a peer-to-peer investment property, and the price differs. But when you will also see the conduct and normal common sense. Most of the time, people think, "Oh, conduct is simply they simply explain it is the co-op use a condo rule, like Jeremy just said." However, if you're looking to purchase as investor investment property, you do need to verify very carefully, have broker, also your attorney to verify building's sublet policy. It's not conduct means that you can use it investment, whatever freely. You need to verify how long would it take that for you to live there in order for you to sublet. Additional sublet fees. Most of the time they do impose a sublet fee if you sublet in the conduct. So that some of the detail need to pay attention. And so now all the document gives to your attorney, buyer attorney, that is very critical because the attorney in Manhattan, normally your attorney would have about a week or so to do the due diligence. And we're going to focus on due diligence today. So one of three documents that seller broker was sent to your attorney is one of the it's this big book is called offering plan that every unit you will have, whether you're co-op or condo, and your attorney will receive this. So can you explain what is included in this thick book, like offering plan? Maybe 300 pages?
Oh, much more. I call this the Condo Co-op Bible, okay?
Bible.
The reason why these books are important is at some point with a co-op or let's say a new condo, a book would have to be filed with the Attorney General's office. And what the book would say is it's offering the details of how this project's going to happen. So for a new condo, they have to file this before they can even get into contract. Now, what's in the book, and why is it important? Is because in the book it'll have the projections of what the common charges are going to be. There are the projections of what the taxes are going to be. The square footage, the floor plans are going to be on the dot, on the money. So you want to take a look. Hey, look, this is what my interior space is. This is how many bedrooms it is. I'm not saying real estate agents wouldn't give you this information, but this is going to be more detailed, and it's going to be more legitimate source because when you're looking at listings, those are just commercials. Those are just ads.
Hello, we are back.
All right, so we had a little technical difficulties, not a big deal. So again, what I was saying is it's very important for your attorney to review it because there's going to be a huge amount of information that will let you know how your building will be. I'm just talking condos here for right now. So often, because when they file these books, the attorney will say, okay, I'll give you a better sense of what your closing costs will be because there'll be a section in there. If there's any restrictions post-closing, that'll be in this book. They'll also let you know what the price that the buildings can be sold at. So each individual unit will have a price that listed in their Schedule A at what the sponsor can actually sell this place for. Of course, they can always add amendments in there, raising the price if the sales do well. But it's very important. It's something that you must go over with your attorney, and it provides you with a wealth of knowledge. So
since it's it's 300 pages, over 500 pages, are there key sections that when you receive that you must read and check?
The Schedule A you must read.
What's in Schedule A?
The Schedule A will have a breakdown of how much square footage your unit actually is, interior and exterior, gross and net. It'll have an idea of what common percentage of that you own within the whole building. It'll have the offering price at when this was first listed from when the sponsor first decided to go on sale, what the first price will be. They'll also have the projected tax it'll have the projected common charge and any various other fees. For example, now the resident manager unit fees will also be in the Schedule A. So you want to go through that to kind of understand what your monthly expenses are going to be.
So basically, I think what you just mentioned is really particularly important when you purchase a new development, because everything's based on there. But if you purchase from resale, the owner, once you become the owner, you should still keep your original offering plan. And as time goes by, the building maybe have some, several, 10 or 20 or 30 amendments goes on based on the building, the whole process. I was just going to make a point to what Jeremy just mentioned, that the Schedule A, if today it actually happened, and in an apartment without the window, it's separate, make it as it's one bedroom with home office. Stay on your offering plan, one bedroom with home office. Then if the seller agent advertises as 2-bedroom, and you pay the price for 2-bedroom, then it's going to create some issue when your attorney do a due diligence, find out that it's actually not a 2-bedroom. So that we do everything we need to base on what's say in the offering plan. And also what happened is that sometimes some buyer, because the 1-bedroom, the living room is really big. That's what we see, that we see 1,000 square feet 1-bedroom in really luxury building versus normally we see 650 or 700 square feet 1-bedroom. So what some owner do is that they put a divider to separate the living room and make it a 2-bedroom, because you look at it's very comfortable 2-bedroom, 2-room still with windows. So the market is a 2-bedroom, but they forgot that over on the offering plan is a 1-bedroom.
Correct.
And the management probably doesn't have a record that you do such a.
The legal usage is going to be how they file these in the floor plan and the offering plans. So again, I've had situations where there's advertisements, they'll say, hey, look, buy this 2-bedroom condo at a good price. My client wants to buy the condo because it is in fact 2 bedrooms. We show up and I realize this is not 2 bedrooms. It was 1 bedroom and it was converted. Now I want to see I would like to see some amendments. I would have to do some more due diligence and find out was that done legally.
Right.
Because if it's not done legally, the effect is it could hurt the value of your apartment, your unit, when you sell it. Because when you sell it, you likely will only be able to sell it as what the offer plan shows, or whatever it was legally converted to show.
And there may be some legal, headache, right, associated with.
Oh, that's another aspect, of course. So, if they did that without the board's purview, or without registering this with the building department, there could be fines and assessment. There could be fines assessed to this unit that you'd have to pay, and it could be quite costly to kind of pay these fines, and correct what the previous owner did.
It is. So, is there any difference when you do a due diligence between the co-op and the condo transaction? There
are slight differences. Overall, the basic generic things that everyone has to do, every attorney would do, is we'd read the minutes. So we'd go to see the building. This is the same between co-ops and condos. We'd go to the building, we'd kind of check out to see, what's the different, what's going on within this building? How healthy is this building? What issues are there with the unit, with the building, with the neighbors? That's the same. We'd also review the offering plans. The offering plans are very, very important because, like we just said before, you want to understand what your closing costs are in a new development. You want to, in a resale, you want to understand, what your floor plan looks like. The things that we spend more time on a co-op is things like the house rules, or how what the actual rules are for transferring or within the unit. Because again, like I said before when we first started this topic, in a condo, you have more autonomy to do things within your unit. Within the co-op, they dictate a lot of rules that they could keep adding on. So we spend more time kind of finding out, okay, you know what, right now you have to live there 2 years before you're allowed to sublet. Now, that just changed last year because the board voted to add that you must live 3 years. These are 2 years is a very common time that you'd have to live to be able to rent it out in the future. But there are many other examples. Pet policies, huge with co-ops. Yes. Number one thing that I see is that they have a huge breed of dog or breed of cat They have weight restrictions. They have number restrictions of how many animals that you're allowed to have. That's not to say in certain condos they don't have certain rules, but across the board with co-ops, they have these types of rules.
Yes. So if you are buying in Manhattan, don't take it for granted that if you have pets, whether you have a dog, you have a cat, you have pit bull, you have Chihuahua, you have German Shepherd 100 pounds, 2 pounds. Don't take it for granted. Please, you do need to share that with your broker who represent you, because they almost actually every building they do have their own pets policy. A lot of it in Manhattan, that unfortunately there are no pets, or if there are pets allowed, there are different permission that
breed restrictions, weight restrictions, size restrictions.
But if you're in a co-op, there's also your pet interview.
That's right. That is
pet interview.
What Anderson is absolutely true. Often you have to bring the pet to the board meeting that you're going to go through, and this goes back and touches the point what I said earlier. It is, in my opinion, more difficult to buy a co-op, even though the price may be a little bit more palatable. It is more difficult because you have to go through this step. They have to interview you and your dog.
And your dog.
Right.
I don't know where I can share this. That some buyer they do give the dog something before a night before.
I don't know. I mean, that I don't know anything about. I don't know anything about that.
Okay. I forgot. Then the second document is the building financials. It's also a very important document to your buyer attorney, and normally we give it 2 years of building financials, the most recent 2 years. So in the building financial, in the due diligence, that what are you looking at? What kind of information?
A big thing with the building financials is how much reserves your building has. The reason why that's important is because these reserves affect whether this building, this unit, is able to get financing. And I always tell my clients that you have to go to the bank and find out to see whether this building is on the bank approved list for this bank. The reason, and if it's not, I'm going to look at the financials further and say why. If it's under a certain threshold, Fannie Freddie will not be able to lend to this building. Why do you care about that? Let's say you're a cash buyer. I deal with a lot of cash buyers. They'll say, I'm buying cash, it doesn't matter to me. It'll affect your resale. Because when you resell and then you can only find another cash buyer, you're limiting the pool. If you're limiting the pool, it's just gonna hurt you for obviously for monetarily. So I always tell people, hey, look, we gotta look at these financials to make sure it falls within, kind of the normal range. Now, this is a good question because people always ask me, well, is it good, is it bad? I generally tell people like this is within a general aspect of what I see, a general range of what I see within the neighborhood. If it gets, it's able to get financing from what I call A-paper banks like Chase, Fannie Freddie endorsed products like Chase, Citibank, Wells Fargo, these big banks. We generally don't have an issue. Also what's very, very important in these financials, you want to see is your building operating at a net positive. They'll have a breakdown of what the building is getting per year. Let's say 2015, the building with the maintenance and the common charges came up to X. How much did they spend? And if you're looking and they're operating consistently and have a deficit, it could be a problem. It'll affect you in your pocket. It'll affect you potentially in resale, or it'll affect you in your immediately buying. Your common charges or your maintenance will have to spike up.
Right.
So these are things that are very important that you can kind of get a snapshot through the financial statements.
So also you can get to see how many units current sponsor still holds, and basically how many units, what's the percentage a sponsor owns in the building is actually matters whether a buyer can obtain the finance or not. At average, the Fannie Mae, if a sponsor can own up to 50%, I think it's based on my understanding with from mortgage broker, that will be still fine. But normally they're up to like 20%. Some lenders allowed up to 50%, and Fannie Mae allow up to 20%. So this is also what part of the attorney's due diligence does. And so Jerry mentioned about house rules earlier. we talk about pet policy and smoking as well. You know, in New York, I know that it's really the non-smoking is really been our norm. That it's so difficult to find a place for smokers. Then, so I want to ask, is it beneficial for a building to have the commercial at the ground floor? And what's beneficial and what's negative?
Well, there used to be an outdated, well, not outdated, a rule of 80-20. All right. Now, how this works, and what I was talking about earlier about condoms. A lot of the reasons why condoms exist is because the co-ops are getting some commercial income. There were restrictions that were implemented in the 80s about, you know, well, how much income can you actually have? The obvious benefit for commercial space in these types of buildings is that you could potentially push down some of your costs for the actual shareholders. So often what I see is that, hey, look, you know, the commercial units are, you know, rents are actually pulling in this much. And this is why you're like, oh, well, I like this building because the common charge or the maintenance is very, very affordable. And when I say, well, I mean, that's obvious because you guys are getting some side income from commercial units. So I do think that, but there are, of course, there are headaches that come with that as well. And there are also obvious headaches. The reason why, because you have to kind of manage your tenants. You know, the board will have to have a separate thing for the management company to deal with. There are issues that arise with these tenants, and you know what kind of nuisance they create for the actual shareholders who actually live in residential buildings. So you know that's general things.
For example, in one scenario, let's say if you look at the building, the financial, the revenue, that every year the building is like a business entity. They have revenue. The revenue from your common charges, the revenue from your laundry room, laundry machine, move-in fee, all kinds of sources that considered the building's revenue. And if today you see the commercial unit, this is 30% of revenue was from downstairs commercial unit, the rent. That might pose a red flag, right? Would it be fair to say that potential concern might be because that you might view this building that what if the commercial unit become empty?
Correct.
Vacant?
That's what I was saying.
Right.
Kind of touched on that point. Is
yes.
There's risks because you're going to have to be dealing with tenants, and these commercial tenants provide income to push down. So that could be a pro. But let's just say you rent to Barnes and Noble, who all of a sudden now nobody buys books anymore, and they were a huge source of your income, and now they're leaving. They're going to leave the 30% like chasm. Well, who's going to make up the difference? The shareholders. The shareholders have to potentially find another a tenant. What if no tenant can be produced for 2-3 years? Maybe we need to have an assessment, you know, and you know that's going to affect your resale value. Everything affects your resale value.
Yeah, that's true. So I'm going to touch on to also besides the attorney sitting in the office read the contract. Oh, by the way, contract. When you review the contract, I know it's a key part of due diligence. What are the key phrase, paragraph, you know, clause that it's very important for the buyer to know? Because I know that most of the time that, as a matter of fact, very few buyers actually read through the contract themselves. You got to have a law degree to read the contract.
Well, if my clients want to read the contract, of course, they're allowed to read the contract. But if you ask me what is very, very important, I'm going to separate two different categories. One is people who are getting loans. If you need financing, one of the most sacrosanct conditions or sections in that contract is the mortgage contingency.
Can you explain a bit that in Manhattan, really, I can't remember when was the last time I ever had a deal that's done as buyer has a luxury to do based on financing contingency or mortgage contingency. It's always non-contingent on more financing. That's why, you know, way back in the last, very first episode we talked about, it's so critical for the buyer to, at the very first day, I always send my buyer to the bank, to the lender, to mortgage broker that, please, you know, give me the pre-qualification letter, pre-approval. It's really critical. And so the reason for that is because most of the time, almost, if not 100%, you know, I would say 95%, the deal transaction in Manhattan are done as a non-contingent on financing. So can you explain the difference between what is a non-contingent on financing?
Well, a non-contingent contract would simply mean that you are allowed to go get a loan, get a mortgage, apply for a mortgage, but in the event that you were denied from your mortgage, you will not get your deposit back. All right, that's just the most plain way I can say it, is that you have to find other ways to purchase this apartment if your financing falls through. If not, you default the contract, all right? You'll breach the contract and create a default, and then your 10%, your deposit, whatever your deposit will be, and generally it's 10%, will be taken by the sponsor or by the seller.
Yes, so generally in Manhattan, it's no-brainer that 10% is a typical contract deposit. Maybe in outside other state, we heard about 5%, but I've never have any transactions 5%. And you mentioned that based on the real estate price in Manhattan, we are talking about $2 million, easy for one bedroom, or $1 million for a studio. Your 10% is $200,000.
It's six figures, right?
Yeah, it's 6 figures. That's a lot. So even for millionaire, it's still a lot of money to lose. That's why it's really important. So, but in terms of finance contingent, that I know that some people thought, okay, since if I have a finance contingency, it means that even in the end, that I don't get my mortgage, I can still have the contract deposit back. I know it's not true.
Oh, that's tough questions here.
Okay, so this is very important because even today, if you sign the contract is based on they give you the finance contingency, when you submit a mortgage application, that you have certain period to obtain. Okay, this is based on financing contingency. Once the lender give you the commitment letter, then the contract would automatically become non-contingent financing.
Correct. The clause, the general clause in these form contracts
Right.
will state that once the commitment is issued, you've satisfied this contingency, and then thus you have to close. A lot of attorneys try to put certain things in the contracts to kind of protect in the event that the lender cannot fund the loan for such a situation. It's arguable whether you can get that in.
Right.
Sometimes they'll be limited. The sellers or sponsored attorneys will limit that provision and will say, okay, only in these instances.
Right.
But what Ann is saying is correct. When you satisfy the contingency, meaning when you get the commitment, this contract is no longer contingent upon anything. You have to, well, not this clause anyway, you will have to move towards closing. If you lose your financing for whatever reason, it would be a breach of contract, and you could potentially be in default and lose your deposit
Right.
as well.
So I mean, so far you probably know that a lot of your money are actually potentially held by your buyer attorney that based on his due diligence, because he needs to do a lot of really thorough work. And so once so you explained clear about the non-contingency, and
Even within the contingency, there are conditions. It's not simply just get a loan, and if you get a commitment, we move forward, and if you don't, you don't. There's timing provisions. So your attorney has to explain to you how long you have to get a commitment. Generally, it's within 30 to 45 days. That's the kind of industry standard right now. Used to be 30, but it's a little bit more, it's more difficult to get a loan these days. So sometimes they'll allow 35, 40, 45 days. Once you get, what if you don't respond? What if you go past the state and nothing happens? There are consequences. Again, the contingency has to be adhered to. So you have to kind of act within the guidelines that they set. Another big one, the one I see the most often, and I spend a lot of time with my clients on this, is how much are you borrowing? The actual dollar amount is going to be listed in the contract. It'll say, hey, you're allowed to borrow up to X, a certain number.
let's say let's use $1 million contract purchase price.
Purchase price $1 million. Let's say you're only allowed to borrow, let's say, $500,000.
Okay.
A lot of clients say, where did they get that number? Well, they got that number from what you offered initially. So you presented an offer with your real estate agent to the seller saying, hey, I want to buy your house or your apartment for $1 million, and I'm going to take a $500,000 loan. Because that condition was agreed to, that offer, and it was accepted that way, they're going to put that in the contract.
Yes.
Well, why does it matter? And I tell you, it's a very simple concept. The reason it matters is it's very obvious to understand that the more you borrow, the less likely you're going to be approved from a loan. So if I might be approved for a $500,000 loan, but I won't be able to get a $600,000 loan. The seller took your offer understanding, you know what, you only needed this amount, a $500,000 loan. It's a very different deal if you needed $800,000, for example. All of a sudden, you become a much riskier candidate. And
because basically, back to our first episode, that the amount of loan that you qualify is really based on your debt income ratio, based on your annual income, based on your adjusted gross income. So the percentage there, it really limits you what percentage you can get, and represent a different degree of risk. Yeah. Correct.
And people always ask me, well, can I physically borrow more? And I said, yes, if you risk, losing your deposit. You can actually, the seller's not going to be able to stop you from borrowing more. So let's say that the contingency only provided for $500,000, and you actually, in fact, needed $700,000. You applied for $700,000, you got $700,000, and then we moved to closing. Then everything's fine. But what's the risk? Is it worth the risk? Is what your question you have to answer. The risk is if you got rejected at $700,000, you went back to your attorney and said, hey, I want to get my deposit back because I was rejected. The seller's attorney will say, no, you did not act within the guidelines of the contingency, and thus, it would be a breach, a material breach, and you put your deposit at risk.
Great. So then, after you finish all this due diligence on the, I've showcased this big, thick offering plan, 300 pages. This is 200 Chambers Street, very luxury, high-end in Tribeca, a good one. Where the one bedroom will cost you $1.8 million. So then your attorney will go to the management company to read the board minutes. So can you explain that what's included in the board minutes and why it's so critical for attorney really make an effort to visit a management company to read board minutes?
The board minutes are very, very important. I touched on this earlier, and the reason why is we've already talked about the offering plan. We've talked about the financials. We even touched on the contract. The financials, the minutes provide a snapshot. They provide a snapshot into things that you wouldn't know. For example, you couldn't tell from the offering plan if the neighbor in 1L was had bed bug, was extremely loud, was causing a nuisance. These kind of complaints might be lodged in the minutes, and you'd be able to look in the minutes and understand that, I don't want to buy 1M. It's too close to 1L, and this neighbor is a nuisance.
It's your watch accurate?
No, it's an hour fast.
Oh, okay. So it's 12:45?
It's almost 12:40, yeah.
Oh, okay. No, because I have a recording afterward.
Oh, okay.
Okay, so sorry. Yeah.
So the minutes provide those types of information. It kind of gets you into kind of the brain of what's going on with your building, because the board is sometimes I call them chatty boards, and they kind of put down everything in these minutes of what's wrong with the building, even rumors or issues that are upcoming. You can't get this from the financials. You won't be able to get it from the offering plan.
Yeah, it's very old Bible.
So you have to understand these buildings are like living entities. So you can understand, okay, you know what? The guy in one, like I said before, the guy in 1L in that example is being a nuisance. You know what? I don't want to live in the first floor. Or you know what? They've already changed the roof 3 times in the last 10 years. What's wrong with the roof? Elevator's down every year. Why is the elevator down? Maybe that's going to be a huge repair, and it kind of pushes me off this building. These types of things happen often, and that is why you must read the minutes.
Or for instance, one shareholder might sue the building or sue the sponsor, which is a very important case that you won't be able to see it. And when there's a lawsuit in the building, what would affect is that even you want to go ahead to purchase it here, given that you love the building and love the apartment so much, it might affect your ability to get a loan from the lender, because lender is more it's quite cautious when there's a lawsuit going on, and of course that it would based on that what type of lawsuit, what is construction damage, what is some personal, it all depends. So really important for the attorney to read the board minutes, and when you when you retain your attorney, I think it's so important for you to verify that whether in their service, whether they does conduct 4-minute reading. And so our time is really passing pretty fast. Originally, I was going to have Jeremy continue to do the new development closing cost.
Well, this is important, and I really want to touch on this because the closing costs differ a lot between a resale and a new construction. And that's another one of the most popular questions people come to ask me is that, hey, you know, my father, my cousin, my friend, they purchased a condo or even a co-op, and it was last year, and they didn't have to pay any of these fees. What's going on? Why do I have to pay this? The custom is that there's certain fees that are going to be borne on the purchaser side, and it's going to be in the offering plan. And so your attorney must let you know what those costs are. And here I go over them, right? I'll go over them briefly with you because they're generally all the same. One, they're going to ask the purchaser to pay the transfer tax. The custom is the transfer tax is always borne by the seller. But in a new development, the buyer is going to be asked to pay the transfer tax. Now, the transfer tax can be quite hefty because any purchase in the city over $500,000 is 1.425% to the city, 0.4% to the state.
So 1.825%.
1.825%. Right. So that's going to be the one difference right there. And that could, you know, if on $1 million or $2 million purchase, you know, that could be tens of twenties of thousands of dollars. A second thing is they're going to have capital contribution to the building. These buildings, they're new. They start off with no reserves at all. So they're asking for a contribution for every unit owner to pay in. Generally, it's 2 months of your maintenance, common charge. And you might think, well, okay, that's not that much, but you have to look at the aggregate of everything that you're going to be putting in here. So this is different from a resale. Generally, a resale, you don't have that. Not always, but generally. Third is they're going to ask you to pay for one of the most unpopular things that people always gripe to me is the sponsor's attorney fee itself.
Sponsor attorney fee, yes.
Right.
Yes.
So this is also borne by the purchaser, and a lot of purchasers say, "Hey, are they picking on me? Is this something that I have to pay that nobody else has to pay?" That's not the case. Everybody's asked. I've bought a few sponsored units myself in the last few years, and I've always had to pay it myself. I got no special treatment. It wasn't that I could, you know, they didn't care. So you know, I still had to pay that. And often now what you're seeing is there's a resident manager, the supers unit, which is going to be borne as a cost on the purchaser side, a one-time fee that you'll be paying at closing for the actual the supers unit. Where did they get that number? They get that number from the unit percentage of the common elements of how big your unit is compared to the whole building.
So this cost really generates a lot, you know, added when you purchase a new development. And so it's really common, it's almost like common knowledge that when you purchase in New York City new development, that this fee will be conveyed to the buyer. However, can you try to negotiate when you put an offer? I would say yes, you can try. And it really based on, you know, everything is negotiable. Correct? And it really depends on the new development you're purchasing, whether their sales, you know, status, the progress. If it's really hot, you know, that happening, for example, Flushing, Skyview Park, the Grand, so happening, hot property, you probably won't be able to get it waived. But in some new development that we know it's been on market for a while, you will. And as broker, I cannot openly announce that yes, it's possible, but it's really based on the supply and demand. Okay, and so so mention that the transfer tax is really high, 1.825, and then the buyer also need to pay, you know, the closing costs also need to pay the mansion tax. There's an additional 1%. Question here, we know that when you mansion tax, when you the purchase price over $1 million, you know, pay the mansion tax. Here comes the buyer and the seller ask, what if I negotiate the price of one bedroom, right? Instead of price of $1 million, I price it $975,000. Would that make $995? Would that make me avoid the mansion tax?
Okay, this is a good question. Frequently, properties in New York City are over $1 million, if not like the majority at this point. The thing with the mansion tax and trying to skirt mansion tax is very simple, is if it truly, this transaction, there are apartments, appraisal value, everything, they're actually transferred for $995,000 or $999,000, that must mean that the value of what's happening, there's no separate any other consideration going back and forth. So if I sell an apartment to Ann for $999,000 and there's nothing else, meaning there's no other kind of side agreement or money for furniture and everything like that, then that is illegal. That is a legal way, or not a way, but that is a legal transaction. If you're saying, oh, I want to spend something for $1 million, $1,050,000, but I don't want to pay the mansion tax. Can we go to $995,000 and then I'll just give you $50,000 cash, or I'll pay you $50,000 for your toaster? That is illegal, and you are skirting taxes there, and then you could open yourself up to many civil penalties and not criminal penalties. So I definitely don't recommend doing anything in that way. If it's over $1 million, it's over $1 million. Now sometimes certain things are priced just under that because that'll affect whether people want to give offers on it. That's fine, because what you're doing is a legal transaction. You're actually selling something for $990. There's no separate consideration going back and forth. That's legal. But again, I would not get in a situation, or be very wary of a situation if somebody was trying to say, hey, why don't we do it for $995 and I'll give you $75,000 for all your furniture. That could be a very taxable event, and they could open yourself to civil and criminal penalties if the AG's office found out.
Okay, so let me jump back to new development a little bit. They say the price today, the price is $950,000, very legit, right? And but because you purchase new development, and what Jeremy just mentioned, that all this sponsor fee, transfer tax, legal fee, sponsor legal fee, everything that convey to transfer to the buyer. This month they say it's $50,000, for example. Sorry, my method. So, for example, would that be considered as part of purchase price and therefore trigger the mansion tax?
Certain things, yes. One thing is the transfer tax. Okay, so there's situations where, let's just use some dummy numbers. If it's a $999,000 purchase, legitimate $999,000 purchase, but the purchaser has to pay the transfer tax.
Right.
It's not fair. I'm not saying anything is fair, but the city treats this as that percentage, that payment that you're making for the transfer tax gets added into your basis. So that $990 purchase, if I have to pay, let's say $11,000 in transfer tax, my purchase is really $1 million in $1,000. All right, and then what happens then? They use that as the actual amount that you have to pay transfer tax on. So you're paying transfer tax on the bulked up rate. So that kicks in, invokes the mansion tax. You're saying, how is that fair? I'm buying $990, I'm paying the transfer tax. I'm not buying over $1 million. You have to be wary. An experienced attorney will understand. You know what? Let's be careful. We got to find out. What's going on. This will actually invoke the mansion tax that you'll have to pay at closing, and this is a discussion of whether you want to move forward because of that. Same thing with the resident manager unit. All right, these co-op, a lot of the offering plans now are having this being added into the basis. If it gets added into the basis and it kicks you up over the $1 million, you'll have to pay the mansion tax. The mansion tax again is 1%. 1% of the overall purchase price, which could be quite hefty. On $1 million is $10,000.
So can you explain a bit why the closing cost for co-op is much cheaper than condo?
Okay, with a co-op, you have one extreme benefit is the closing cost. And one of the biggest ones is the mortgage reporting tax. You do not have to pay a mortgage reporting tax with a co-op because they don't treat it as real property. Now, every other thing, co-ops are treated technically as real property within the city and the state. All right, when you transfer, you have to pay transfer tax. Transfer tax is only for the transfer of real property. But what I said at the outset is you're buying personal property, you're buying actual shares. So how come you have to pay transfer tax? Well, they treat it as real property. This is one instance where they do not. So you don't technically have to pay. You don't have to pay the mortgage reporting tax, which is almost about round. I'll just use rough numbers for the second time. Okay.
So we're back. The reception wasn't good today. I need N1, my sister to help. So basically, Jeremy was talking about the mortgage recording tax, and
that's one of the biggest costs that you have because you save. about 2% off what you're borrowing. So let's just say I'm getting a $500,000 mortgage. 2% of that for mortgage tax is about $10,000. It's a lot of money. Second is title insurance. You don't have to buy title insurance because you can't. Well, it's not you can't, but you don't get title insurance with co-ops. And because of that, you're already saving a few $1,000s because title insurance is based on a percentage of what your overall purchase price is. So you add these together, you're saving quite a bit of money the closing costs anyway, on a co-op.
Oh, okay. So actually, you mentioned something really important. I actually totally forgot. The title insurance and title search. And title insurance can actually add up quite a lot of money. But why is it important for a buyer to have a title search and title insurance? This is very important.
I tell every client, you have to get title insurance. There is no amount of, I can't say this enough, title insurance is probably one of the most important things that you have to get in any real estate, with real property, with condos and with houses or with multifamilies or even with commercial. The reason why is you have to make sure the chain of ownership, everything that happened before your ownership, was not broken. You buy a property for a few $1 million, you want to have the comfort of knowing that prior to your ownership, nothing bad happened. Now, of course, people say, well, there's some nuances to it, and that's true. But overall, what I tell people is you don't want something happen where someone knocks on your door 2 years from now and says, oh, there was actually a private mortgage reported on this property for $100,000. I want to foreclose on that, or I want my money. You'll say, if you have title insurance, you'll say, you know what? Let me reach into look at my policy, because I have insurance that will protect me from everything that happened prior to my ownership. Very, very important.
So what's the cost?
It's statutorily set. So the percentage of whatever the cost is for your title insurance is based on the price of what you're purchasing and your loan amount. So it doesn't, when people say, hey, my title insurance company is cheaper than the other one, what they mean is just the municipal searches. So, every company will have, or the abstract companies will have perhaps kind of different prices for their search fees, but the actual premiums are set and they cannot deviate. There's actual laws of what they can charge. And so your $1 million purchase for this condo will be the same for the next $1 million purchase for the guy down the street. Now, his company might charge slightly less for, again, the search fees, or more for the search fees. So that's when people talk about, well, my company's cheaper, or this and that. That's what they're talking about.
So usually the session is 30 minutes, and we really run well past 30 minutes in 3 different segments with the Wi-Fi disruption. We will put together as one complete episode, and we'll put different, the content index, so you know that which area you could, which minute, second, you can shoot right there for the subject, the topic that you're interested. As I'm going to Sinovision for recording, but I might as well ask Jeremy, just borrow him a few more minutes then. So Trump-elect, and I'm not going to ask you whether you vote for Trump or not. So what's your view what do you think for the real estate in 2017? What impact, any kind of impact might be from the...
Well, there's already been a slight immediate impact since his election. Interest rates are a little bit up. And because of that, I've had a lot of calls from clients saying, I want to lock in the rate, or, some people had, different approaches as to some people feeling like I have to purchase now. Historically, we're at an all-time low with interest rates. That's just a fact. And people want to take advantage of that right now. Some people believe that may end in the near future because of this election or the new, with Trump taking office. So it depends on what you feel, that you want to take advantage of something like that, or you want to wait. Now, my personal view is rates can't stay this low forever. So we've been in a real estate boom for quite a while, for a few years now.
Yes.
And is it going to tank? No, I don't believe
about
that.
6 years.
It's not going to tank, but is it going to level off in certain areas, or are we going to see some bump in rates? But that I think is in the near future.
Great. So we're going to wrap up, and I hope it's very helpful to a lot of buyers, and especially in Manhattan, a new city. And Jeremy Wang is a founding partner.
Partner, yes.
Founding partner, and also managing director of Yeung and Wang office.
Right. That's right.
Yeah, and so they have an office in Manhattan Midtown, around Grand Central. Is very convenient, and also in Flushing as well. And so, if you have any question further than this, please feel free to contact him. Then, as always, we're going to post his business card on the Facebook website. Thank you. Have a wonderful Friday.
Appreciate your time, everybody.
Thank you. Bye bye.
Take care.